All right. Hello, everyone. Welcome to this estate planning webinar. We'll wait about a minute to let people kind of roll in here before we get started. But today we have Amanda Hespen here to share with you guys a lot of information about estate planning and all of the different parts and pieces that kind of go along with that. So thank you, Amanda, for joining us today.
You're welcome. Thanks for having me.
Yeah. So for today's webinar, we're going to be using the Q&A feature, which can be found on the bottom bar of your screen. So if you have any questions throughout the presentation, please feel free to drop those in the Q&A box. And I'll be watching for those rolling in so that Amanda can try to answer those for you. We're also going to be recording the webinar today, and so you'll receive a recap email with the recording afterwards, or you can also find it on our YouTube channel. So you can always go back and kind of reference things that you may have missed. So without further ado, I'm going to pass it over to Amanda to get us started.
All right. Thank you, Erin. Thank you for having me, Stein Financial. And we're going to talk a little bit about various estate planning topics today. I'm going to share with you my screen that has a PowerPoint on it. And there's a lot of topics in this PowerPoint that we are going to talk about today. I think everybody can see that. Erin, can you see that? Okay, perfect. Yes. We're going to talk about all these different things today, and some of them may be more than others, because I do want you to use that question and answer box feature, and I will be glad to address your questions as we go through this webinar. So if we're talking about a topic you have a question on, let's talk about those questions while we're still on that topic. So my name is Amanda Hespen. As Erin said, I'm an attorney in St. Paul. My office is kind of in the Midway neighborhood of St. Paul. Our practice consists of 3 attorneys, myself and my partner Jeffrey, and our associates. And all we do is estate planning. So you can't technically legally say we're specialists, but that's really all we do. We don't do divorce or bankruptcy or anything else. And that practice area kind of is relatively broad still in terms of what we actually do. So we help a lot of clients set up their estate plans like wills and trusts and powers of attorney, but we also help clients when a family member has died and they're going through that process of either probate or maybe trust administration. And then we also sometimes help clients with kind of elder law issues or nursing home issues. So that's kind of a summary of what we do. I've been practicing with Jeffery since I was licensed in 2008. So we've been together along quite a while, actually. But we are going to start talking today about specifically start with the topic of wills. And so what a will does and what a will doesn't do. So, probably some familiarity with what a will actually is. To make a will, it has to, a will is a document. Of course, it has to be put in writing and it has to be signed. To make it valid, it has to have 2 witnesses. And those witnesses actually can be anybody. Doesn't really matter who they are, which is kind of a unique thing. It could be your friend or neighbor or brother or sister. But in a will, what a will typically would say is a couple really important things. One is going to be where your money goes. So what assets do you have and where do you want them to go when you pass away? And then the other thing that your will is going to say is where or who's in charge of your estate. So Minnesota, we call that the personal representative. Means the same as executor, but it's kind of a different phrase we use here in Minnesota. And so typically you would designate that person in your will. Okay. So that's basically what a will is. That's it. It's not anything special other than that. A lot of times it gets kind of put in a drawer and ignored for many, many years until it's needed. What a lot of people don't realize about wills is that if you have a will-based estate plan, your estate does not avoid probate. Okay. Probate and wills kind of go hand in hand. So my guess is I've probably surprised a couple people on this webinar when I say that. But we're going to talk more specifically about probate. But wills actually only control your probate assets. And so let me give you an example of something that isn't affected by a will. Some people call those will substitutes, like a beneficiary designation, for example. So let's use the example of your will says your entire estate goes to your 3 children equally, but on your IRA account, you've listed only 1 child as your beneficiary. That IRA account will go to that 1 child, and that 1 child does not have a legal requirement to split that account with his or her siblings per the will. Okay, so the will only controls the assets in probate. That beneficiary designation trumps and supersedes the will. Okay, so we sometimes call those will substitutes because those beneficiary designations are as important as a will or trust. So really, you know, a good plan to keep those up to date and make sure you know what those say at all times. So, and Aaron, please, I can't quite see the Q&A. So if for some reason there's one and you want to interrupt me, by all means, go ahead.
Okay, we did already have a question roll in, so I'll answer it or I'll ask it. It says, what is the difference between PODs and a trust? Can you use POD for real estate?
Great, good question. So, you know, on that topic of kind of what some people call will substitutes is, again, I think people are starting to understand and realize that wills do not avoid probate. They certainly are a good tool to use for estate planning. But if there's a big preference in probate avoidance, that has become quite widespread. So it was very common, you know, many years ago, even, you know, 40 years ago, to take out a life insurance policy or an IRA and have a beneficiary attached to that asset. And now in today's world, you basically can add a beneficiary to almost anything. And a lot of times those, you know, account features are called POD, payable on death, or TOD, transfer on death. And so the ability to utilize that beneficiary designation is pretty widespread. You can add it to your bank account at the bank. You can add it to CDs. You can add it to your treasury bonds on Treasury Direct. You can add it to brokerage accounts. You can add it to real estate. It's called a transfer on death deed. It is a deed that you would have to sign and record with the county where your property is, just like a deed when you buy your home. And that must be done before you pass away, obviously. And you can do it for cars now. So motor vehicle will allow you to add a beneficiary to your car title. So it's a pretty widespread ability to add that account feature. Again, it's really important that those are accurate because they do supersede your will. And so it's going to affect where those assets go. I think the second part of that question was, what's the difference between a POD and a trust? Both of those tools are probate avoidance tools, but how they interact with the asset is going to be slightly different. And we're going to talk in more detail about trusts and how, you know, what's the benefits and difference of a will versus a trust. But there, you know, the biggest difference, of course, is that a trust is something someone would create while they're alive and still manage while they're alive. But they kind of work very similarly in that probate avoidance piece. So PODs, transfer on death deeds, they're very highly effective tools. The one thing I would say about it, though, my caveat is that you really want to make sure that it makes sense for your situation. Sometimes people are very adamant to avoid probate because they've heard, you know, all these negative things about it. Of course, you always hear the negative things, because if we heard all the easy stories about probate, that's not entertaining. But I would say that having a plan where you have beneficiaries on everything, trying to avoid probate, sometimes can create conflict more than just having the probate. And what I mean by that is specifically with real estate is that, an IRA account or some other type of brokerage account, those are things that can be relatively split easily. So if you've got 3 kids on an IRA, they don't really get along. It doesn't matter. They each individually collect their 1/3 of that IRA account. But if you put 3 kids on a house to inherit it, and mom dies, now 3 people own a home together and they have to collectively figure out what to do with that house. And in Minnesota, real estate is also owned by your spouse, even if their name isn't on the title. So they have to sign off on the transfer. So 3 people who don't get along and then add in their spouses who maybe also don't get along can certainly create a potential for conflict. So sometimes not the best plan. Erin, do we have any other questions about wills at this point, or?
Nope, I don't see any others
Okay.
right now.
Okay, good. So let's talk a little bit, we'll delve into the topic of trust and how they differ. And so there's lots of different types of trusts in estate planning. And so the word trust is used quite often. I kind of want to focus in on kind of the most commonly used trust that's done for estate planning purposes, pure estate planning. And that's what's called a revocable trust or a living trust. A lot of attorneys use those phrases interchangeably. And so a trust-based estate plan differs from a will. One of the big benefits, I guess, and difference is that trusts are intended, if they're set up correctly, to avoid that probate process. And how that happens is that a trust is like an entity. It's kind of a way to own your assets. So there's 2 steps to a trust. The first step is the document itself, much like a will. And then the second step is transferring your assets into the name of a trust. So first, when we're talking about what is a trust or what does that document say, there's going to be a couple different parties to that trust. One is going to be the settlor or the grantor, the person who is creating the trust. They're the one who's going to sign it, determine what it says in terms of distribution of the assets, and put their assets in the trust. Okay. The second party is the trustee. So the trustee is the person who manages the money. Typically, a competent adult creating a trust is going to be their own trustee. So they're not necessarily giving someone else the power to control their money. They're going to retain that power as trustee. And then the third party is the beneficiary. And again, in a revocable trust situation, you're going to retain your own beneficiary status. You will also obviously designate, okay, who gets this trust when I'm gone? Where does this money go when I die? So those would be your contingent beneficiaries. So let's give you an example of a client. His name is John Doe. I'm just making someone up. And he's a single man and he wants to set up a revocable living trust. In that scenario, John Doe is going to be the settlor, the trustee, and the lifetime beneficiary of that trust. So he will fill all of those roles. And now you're probably thinking, I don't understand the point of doing that. But again, it's going to be purely for probate avoidance, at least in a single person situation. The document itself can be, as simple as saying, when I die, my money goes to my 3 kids equally. But it can also be quite complex. Oftentimes, trust-based estate planning might include distributions over a staggered period of time. Perhaps the kids don't get everything in one lump sum. Maybe they get it a third every year for 5 years, or 3 years, or maybe they get it a third 5 years apart. So when they're 25, 30, and 35, or something like that. So it can have more complex provisions in there. Or maybe you want to leave a portion of your estate to your spouse, but it's a second marriage situation. And so you want your spouse to have access to the money, but not be able to spend all of the principal. Maybe they only get a portion every year so that your children from a previous marriage get the balance when your spouse dies. So there's some more complexity that you can certainly establish in a trust-based plan that isn't really as available to you when you do a will-based plan. But it's really step 2 that is kind of the probate avoidance piece. So I'm kind of fast forwarding a little bit to that probate topic, but and we're going to talk more exactly what probate is. But probate is triggered when someone dies and there's an asset in their name alone. So there's no beneficiary, no joint owner, and no trust involved. And so when we're thinking about, okay, we've got to put our assets in the name of our trust, that's step 2. We don't want anything in the individual's name. So back to my example of John Doe. Let's say he has a house, for example. He owns that house. He's got a deed that says John Doe. We don't want the house to be in the name of John Doe. We want the house to be in the name of his trust. And I realized I didn't switch my screen over to revocable trust here. And so when we create this trust, we're on step 2 of funding it. We're going to actually have John Doe convey the property from himself to his trust. He, as the trustee of his trust, will still manage the property. He'll still own it and be able to sell it and do whatever he wants with it. But it won't be in his individual name. And so remember, that's what triggers probate, when there's an asset in somebody's name and they're deceased. There's no one who has legal authority to that asset. So step 2 is really the big piece, the big difference between a will and a trust. And that's kind of that probate avoidance piece. Okay. Do we have a question? My thing is red.
We had another question come in. Are assets in a trust taxable upon the death of the grantor?
That's a great question. So in terms of tax on a revocable trust, so we're going to specifically keep in mind we're talking about a revocable trust or a living trust. So what I mean by that is that it's something that you create while you're alive. That's why we call it living. And revocable means that you can amend it or change it at any time, the document itself, and you can draw the money back out of the trust at any time. And so for purposes of the IRS, they don't care about revocable trust. A revocable trust or any assets within it is going to be taxed to the grantor, the person who creates it, on their social security number. So let's say you put a brokerage account in the trust, and that brokerage account is spitting off dividends and has gains. That tax activity, that activity will be taxed to the social security number of the grantor. So they're going to do their regular 1040 income tax return, okay? When the grantor of a revocable trust dies, the trust becomes irrevocable. And so now it is a separate entity for tax purposes, just like an estate would be. So if you have a will and you have to do a probate, your estate will be a separate tax entity that gets its own EIN. So wills and trusts are the same when it comes to income taxes. Whether or not the assets within the trust are going to be income taxable to your beneficiaries depends on the assets themselves, okay? So anything that's post-income tax, like again, a brokerage account, a savings account, a CD, or even a cabin or a real estate investment, all of those assets will go to your beneficiaries income tax free because they get what's called a step up in basis. So the basis of those investments goes to the fair market value as of your date of death, and wiping out any capital gain, and your beneficiaries get to reap the benefits of that. So they might get a cabin. Let's say your cabin, for example, was purchased at $100,000, and now in 2023, it's going to sell for $400,000. That's the fair market value. That's now the basis. And so if they sell it at $400,000, there's not going to be any capital gain there. The other assets that could potentially be in your trust or in your estate, perhaps, not necessarily in a trust, are IRAs, your pre-tax retirements, pre-tax annuities, your 401ks. Those assets will continue to be taxable to your beneficiaries, whether they flow directly to an individual beneficiary or through your trust or through your estate. They're going to be taxable eventually. Certainly, there are lots of options in how you draw out those funds. That's what your financial advisor can help you with. But they will be income taxable because remember, as the person who contributed to those, you didn't pay tax on them if they're pre-tax, if they're not Roth. And when you draw on them, they're going to be taxable, and that continues for your beneficiaries.
And then we just had another question asking if you could go back to the previous slide on revocable trusts.
Oh, sure.
Just for a second. And then we had another question come in. It says, is a trust needed if one has a TOD on their home?
Is a trust needed if one has a TOD on their home? So that kind of, unfortunately, I'm going to probably say it depends more than people like today, and that's a good lawyerly answer. But I guess, again, it would depend on what their goals are. So the way that I approach estate planning is going to be very educational. So just like today, I'm kind of just explaining things to you, and that's what I do in all of my client consultations as well, is just say, okay, tell me what you have for assets, tell me who your family is and what your distribution plan looks like, and then I'm going to give you the options and you decide. If you said to me, Amanda, I don't care if my estate goes through probate, I'm going to be dead, which a lot of people do, honestly. I mean, it sounds kind of crass, but people do say that. Then I say, great, you can do wills. But if you have a strong inclination to avoid probate, then we're going to definitely explore either a trust or some of these other beneficiary options. Now, if you have beneficiaries on all of your assets, including your house with a TOD, you may not need a trust to avoid probate. So that question is going to kind of be, it depends on what your goals are. The big difference between those two, and let me kind of explain this. The example I gave you before of the house going to 3 kids with a transfer on death deed, and they don't all get along, and then maybe their spouses don't get along, that would be something that could be mitigated with a trust. Because the way the trust works is that it's much like a will in terms of naming a successor trustee who's going to manage that process when you're gone. So again, a will would have one person in charge. There would be this kind of bucket, this pot of money in your estate. In that process, we pay bills and we kind of go through that probate process. And then at the end, we're going to divvy it up and give everybody their money. That would be what would happen with a trust as well. So there'd be one kind of person in charge usually. You can name co-trustees, but usually there's just one trustee who kind of does all the work of the administration, paying the bills and everything. And then we get to the end and we give everybody their equal shares. So that's kind of how those two different documents work. Of course, trusts just kind of go right past that court proceeding of probate. With beneficiary designations, we don't really have that one person in charge. We don't really have somebody who's that fiduciary with the access to all the assets, who's doing all the work and then dividing up the money. It kind of happens in a less organic way. The assets are all divided right away. And then they kind of have to collectively work together to make sure someone paid mom's funeral and the others reimburse them, and someone's paying the electricity at the house, and someone's shoveling the driveway and getting it ready for sale or whatever it might be. It's much more of a collective effort. So it really depends on your family dynamic. That's my opinion anyway, is, if you want to do a probate avoidance plan and have beneficiaries on everything, one of the keys there is that everybody gets along and can work well together. Are there other questions?
Nope, we're all good. We're all
Okay.
caught up.
And Erin, can we send, are you able to, does your company allow you to send out this PowerPoint in case I missed a slide or two?
I believe we can, yeah.
Okay.
Or a typed up notes version too.
Okay, perfect. Yep. Yeah. That way, if you're missing, if I'm not clicking, I apologize for that. I get into the conversation so much that I forget to click. So if you're missing something, certainly we'll get you this PowerPoint.
Yeah.
In terms of other types of trusts, there certainly are other types of trusts. Irrevocable trusts are used in estate planning, but usually for a very particular reason. One being estate tax planning. So we're going to touch on estate tax here briefly. Minnesota does have its own estate tax. It's a $3 million exemption. So that one's kind of a little bit trickier than the federal exemption, which is 12.9 million. And so what that means is each individual can pass at their death that amount before there's any kind of estate tax implemented. And so when I'm talking about estate tax, it's a different tax completely than income tax. You're still going to have those potential assets that'll be subject to income tax, your IRAs and your 401ks and those pre-tax annuities and things like that. But estate tax would be above and beyond that income tax if it is something that your estate is subject to. So sometimes clients will give money away, put it into an irrevocable trust that they really can't get back to or can't change or access, with the intention of reducing their estate. So if their estate is at 5 million, they give away 2 million. They don't want to give it directly to their kids right now, but they want to put it in a trust. They might do that in an irrevocable trust so that their estate, when they pass away, is only valued at 3 million, which would then mean we're avoiding estate tax on $2 million. So those are going to be some very finite situations where we're trying to do some kind of tax planning. The other reason we use irrevocable trust is if we've got a disabled beneficiary who's on some kind of benefit program like Social Security disability or medical assistance, which is the federal program known as Medicaid. And so we have to use a trust so that we can protect that beneficiary, the disabled beneficiary's assets, but also their benefits, the benefits they receive. So those are kind of two very finite reasons we would use an irrevocable trust in estate planning.
And Amanda, we did have a couple more questions come in.
Sure.
So the first one asks, will we need an attorney to draw up a TOD?
So I always tell clients or people, because I do this kind of topic in community ed settings, is that there's no legal requirement to have an attorney do any of these documents. So you can write your own will, you can write your own trust, your own power of attorney, healthcare directive, and you can even do your own transfer on death deed. So there's no legal requirement by any means. The risk you're taking, of course, is that you're doing it incorrectly. And so then the cost to your estate to fix the error is probably going to be more than what it would cost just to have an attorney do it correctly in the first place. So that's my caveat on that piece. But no, you don't need to have an attorney. All these forms, actually, a lot of forms are readily available on online or on even the Attorney General's website for the state of Minnesota. But again, I just caution people that you're not necessarily paying an attorney for documents. You're paying them for kind of their advice that it's being done correctly.
Mm-hmm. And then, should a Roth or an IRA be in a trust?
It's a great question. So an IRA or a Roth actually can't be owned by a trust. It has to stay in your individual name. With your estate planning or how we want to set up your estate or what your goals are in terms of distribution, that's when we would kind of figure out, okay, what should we put on your IRA for a beneficiary designation? But as probably most of you know, IRAs have these tax deferred or tax advantage statuses, whether they're tax deferred or whatever the advantage is. But someday you're going to have to start drawing on those accounts and take your required minimum distribution. And that required minimum distribution is based on your date of birth and how old you are. Of course, trusts don't have dates of birth, so a trust can't actually own an IRA. It's got to be in an individual's name, but it can be a beneficiary. That's one option if we had to do that.
All right, and then we have one more right now. Says, is an LLC better than a trust?
I guess that again would be it depends answer. I'm not quite sure what they're trying to what end goal they're trying to get to. So it's possible. LLCs are really designed to give you liability protection. So really a great tool to use in terms of any kind of business venture. If we've got a rental property in your name and you want to make sure that if the renters have, guests there who fall down, you're not going to be sued. A good strategy to utilize if we're trying to get liability protection, which is not the same as a revocable trust. A revocable trust being your assets doesn't necessarily give you protection from liability. It gives you protection from probate, but not from liability. Now, the LLC itself would not avoid probate. So if your goal is a probate avoidance, an LLC is owned by its members. So when we create an LLC, even if it's a single member LLC, we issue certificate shares or member units, and those member units could be in your individual name, and then that individual asset is going to be a probate asset. So in reality, when I have a client who has a rental property or a couple of rental properties, or they have a small business that they own, we might have both. We might have an LLC and a revocable living trust. Other questions at all at this point?
Nope, we're all caught up right now.
Okay, perfect. So let's talk, we've been talking a lot about probate, and but I want to kind of just make sure that I've covered all the bases of exactly what is probate. So again, a lot of people kind of have a negative connotation when they hear the word probate. I wouldn't say that it's necessarily always bad. It can be very much an administrative process. It doesn't have to be a very complex, drawn out process. It certainly can be if people are litigating or fighting over the estate. But it can be as simple as being done in a matter of 4 months. That's kind of the minimum timeline, or it can take years. So let's first talk about when probate is necessary. So again, the very first thing when I have someone call and say, Grandma died, I have her will, I need to do a probate, I'm always going to ask them if they know what she had for assets, because her assets are going to be the number one controlling factor in whether or not we need to do a probate. So someone might have a will, but they might not have any probate assets, or maybe they don't have any assets left at all. Maybe they've spent through their estate. Then there really would be no need to do that probate. But so the first thing we're going to do is, okay, we're going to try to get an inventory if we can of what they own. If the house has a joint owner, for example, maybe it's a married couple and the first spouse dies, the house is in joint ownership with the other spouse, that's actually not a probate asset. It's going to go automatically to the surviving spouse. If they owned all their bank accounts jointly, those are going to be non-probate assets. If the decedent had an IRA with a beneficiary, that's a non-probate asset. And then let's say they had a small life insurance policy with a beneficiary. Again, that's a non-probate asset. So those assets are going to really be important when we're trying to figure out if probate is necessary. If someone passes away and there is anything in their individual name, no joint owner, no beneficiary, no trust, then we are going to go through that probate process. So the process itself is, again, pretty straightforward. It's actually an administrative court process. So all of it is done over Zoom. None of it has been reinstated in person. So even if you have a probate hearing, it's over Zoom. But the process itself is essentially doing a couple things. One is if there's a will, we're going to confirm that the will is valid. You're going to give anybody who has an interest in the estate an opportunity to object to the will. And you're also going to give creditors notice that the estate is being opened or that there's going to be a probate. And that gives them an opportunity to make a claim against it. So if there's any kind of money owed to anybody. And then the last thing that happens is if if there's no objections and everybody agrees, the court is going to appoint an executor. Again, Minnesota calls it personal representative. So once that appointment occurs, that person would have the authority to do anything the decedent could themselves. So sell their house, file their taxes, pay their bills, collect their accounts, do all of the things they need to do for the administration. Couple things that surprise people about probate. One is, let's say you have a will and it excludes one of your children. Maybe you're estranged, you haven't seen them in 30 years, but it excludes them. That child being an heir of yours, an heir means that they would have received a portion of your estate if you did not have a will. They are entitled to notice of the probate. So that sometimes can create a little bit of a problem. If we have somebody who's been estranged, but they might come back and say they're entitled to assets, even though your will says they don't get anything, they could obviously object to that, okay? So that sometimes surprises people. They'll get some notice about a probate that they're not even in the will, but they may have been an heir. The other thing that surprises people about probate is that it's public. So not only is that notice that has to go out to the creditors published in a paper, everything filed in probate court is available. You can go online and search up Minnesota court records and you can get a copy of those documents. So sometimes that kind of freaks people out about probate. But again, if there's no contest, no conflicts, it is pretty administrative. So it can happen relatively quickly. The probate court is also the place that your estate would go, though, if there is a big conflict. So someone is litigating, contesting the will, saying you were unduly influenced or that you didn't have capacity to do your will, or maybe they're saying that they should get more or whatever the issue is. That same court that kind of administratively processes non-contested probates are also going to be the ones who hear the contested probates. So you're going to have kind of the wide range of easy to complicated as it relates to probate. I would say that, most of the probate I see, I don't do litigation. I don't do estate litigation. So if, anybody needs an attorney that is going to contest a will or fight, your sibling over something, I certainly can help you find one. I know a lot of good ones, but that's not me. So a lot of our probate work is going to be very administrative. I do obviously a lot of probate administration, trust administration in combination with setting up estate plans. Obviously, that is a kind of good mix of work, and you can see if there's any issues on the back end. You can certainly take that knowledge into your drafting on the front end. In terms of when I would say probate is somewhat something you might want to consider avoiding is a couple of them. One is that issue where you're excluding an heir. If you really want to exclude a child, but they may come back to contest your estate. If you set up a trust, it's entirely private. Certainly your heir could contest your trust. Don't get me wrong, trusts are very much contestable, but it puts the burden on the person who's going to contest. They're not going to automatically be sent a notice saying, hey, we're doing this probate in court, and all you have to do is call the court to contest it. They would have to proactively bring that petition to pull the trust into probate court and contest it. So it's much more work on the person contesting. So that's kind of a reason to kind of avoid probate if that's your issue or part of your family dynamic. And then the other reason is if you have real estate in multiple states. So probate is not, it's very state specific. And so it's not universal across states. So if you live in Minnesota, but you have a Wisconsin cabin and you pass away, both a Minnesota probate would need to be done for your Minnesota real estate and your Minnesota property, and one in Wisconsin for that Wisconsin property. So that can create obviously more complexity. If you don't have an attorney that's licensed in both states, that means you might have two attorneys for the probate. So it's just a lot more work than maybe what we could avoid if we would just put those assets in a trust. So that's kind of the two times I would say, yeah, it makes sense to avoid probate. Questions about probate at all, Erin, that you see?
Not that I see right now. Nope.
Okay, got it. On the flip side of probate, we can obviously we help clients walk through a trust administration as well. The nice thing about trust administration is that, again, there's no court filings. So a lot of times our clients are able to do a lot of it without, maybe with a little assistance from us at the beginning, trying, kind of getting them on their way, making sure they know what they're doing, and then usually working um, through that process without a ton of effort by the attorney. Certainly, we can help as much as clients want and need, but it's not going to be as hands-on necessarily as the probate, simply because of that court piece, the court filing piece. But trust administration does still require the trustee to, follow the document and fulfill their fiduciary duties in terms of the administration. I just want to circle back here just a minute. PowerPoint is still on estate tax planning, and there's a reason why I did that, and it's because I wanted to just touch briefly on trust planning as it relates to married couples. And so, as you can see, this slide says that Minnesota estate tax exemption is $3 million per person. And so, a smart person would probably think and assume that a married couple together would be able to pass $6 million before there's an estate tax issue. But the one caveat for both the federal and the Minnesota estate tax is that those systems have what is called an unlimited marital deduction. So what that means is that when one spouse dies and leaves everything to their surviving spouse, they give your estate a deduction for giving everything to spouse so that no tax is owed or due in that scenario. So that's a good thing, with the exception that the first spouse's exemption from estate tax is not used then, and we actually, at the Minnesota level, lose it. At the federal level, we get to elect what's called portability. So a spouse can kind of claim their deceased spouse's exemption and use it at their death. But Minnesota is a use or lose situation. And so if we've got kind of that traditional estate plan between married couples where they leave everything to each other on the first death and then to their kids, they really should be planning for them to only have a $3 million exemption unless they set up some kind of tax planning strategy to utilize both of their $3 million exemptions. And again, that's something that we would do in a trust-based estate plan. So we're going to set that up with trust where we utilize that first spouse's exemption. Sometimes it's called the family trust or the credit shelter trust. Attorneys kind of use a lot of different phrases. But those trusts are kind of created with the estate tax planning in mind. So kind of another reason why some clients will utilize a trust versus a will. Maybe it's not a probate issue. Maybe it's more of an estate tax issue for a married couple. That's not really a single person issue, because single individuals, again, they get $3 million and that's it. So probate avoidance is kind of the key for will versus trust in a single person situation. Okay, so now I'll get us caught up here. We've got a couple different slides here. We've got the probate slide, and I know I'm not necessarily putting these out there as I'm talking about it, and I'm happy to send these out so that everyone can read them after the fact. And then we've got that trust administration slide. Again, it's much simpler than a probate, mostly because there's just not court involvement. Last thing we're going to kind of cover today is disability planning. And I call it disability planning, but really the main topics that I want to cover are the power of attorney and the healthcare directive. And we really would call that estate planning too. So when you're going to do a will or a trust or something like that, you definitely still want to put in place a couple other legal documents. And they're really more for disability planning, but we're going to kind of do that all together, and usually it's going to be called estate planning. Really, really important, actually. The power of attorney, I can't emphasize enough how important the power of attorney is. So a power of attorney is a document that says a person, they're called the principal, is giving someone else. They're called an attorney in fact. They don't need to be an actual attorney, but they're just named in a power of attorney. They're giving that person the ability to manage finances on their behalf. So it's going to be things like paying your bills and making sure that your health insurance is going to cover, the surgery that your doctor wants you to have, or basically talking to anybody on your behalf in terms of finances, contracts, insurance coverage, things like that. So it's really essential. Even married couples need it for each other, because a lot of times you kind of assume that you have the authority to speak about your spouse or for your spouse, and you don't necessarily have that authority. And I've seen that actually before. I had a situation in a file where husband had a massive stroke. They didn't have any estate planning. Wife actually wasn't on the house, but even if she was on the house, there were other individual accounts in husband's name, like his IRA, things she wasn't on. He's in 24-hour care. He has been for several years. He did not have a power of attorney, so we had to petition the probate court for her to become his conservator. It's a very expensive process. She had to be bonded. She has to do an accounting to the court every year. And really, it was just to get access to her husband's assets and to her house. So very, very complicated and very costly process, which could have been mitigated with a simple power of attorney. The power of attorney should also consider naming a successor. So you'd name your spouse and then maybe a successor in terms of making those decisions if you are both disabled. Powers of attorney end when you pass away. So that sometimes surprises people. If you have a power of attorney for your grandma, you're writing her bills, you're paying, writing checks and paying her bills, and then grandma passes away, you need to stop using that power of attorney then. You can't continue to use it once the principal dies. At that point, of course, if you were accessing her account with the POA, you wouldn't have access unless maybe you had POD, which is payable on death. So sometimes you do both, POA and POD. Do we have a question?
We did have one coming. Yep.
Okay.
Asks, does the $3 million include beneficiary money?
Oh, okay. So the estate tax exemption. Yes, the answer is yes. So estate tax, you guys probably know by now, Minnesota is a very tax heavy state. So when the question is, what does that $3 million include? It includes everything. Minnesota Revenue doesn't care if you have a beneficiary on it, if it's in a trust, if it's a probate asset, if it's your life insurance proceeds. Life insurance, a lot of times insurance agents will say, hey, buy some life insurance, it's tax free. Yes, it is income tax free to your beneficiaries, but it's not estate tax free. So yes, when you're trying to figure out, do you have an estate tax issue, you've got to list everything you have. And you've got to do the value of your homestead and the value of your other real estate and all of your cash in the bank and all of your retirement. So yeah, a lot of times clients are like, oh, I don't have $3 million. And then they do the math and they're like, oh, shoot, I do actually have $3 million. So yes, good question. Thanks for clarifying that. Do we have any questions at all about power of attorney?
I don't see any right now. Nope.
Okay, perfect. But super, super important. I'm sure that you guys in your office, Erin, probably see the importance of this sometimes. Mm-hmm. The IRAs, those are big ones. They are never going to be joint between a married couple. So if you need to access your spouse's IRA, or your daughter needs to get in because you're disabled now or you have dementia, power of attorney is huge.
We did have one come in quickly here.
Oh, sure.
It says, are there different levels of power of attorney?
Different levels. That's a good question. So I think what they're referencing is that there's lots of different types of powers of attorney. And those phrases are kind of used interchangeably. For example, you can do what's called a common law power of attorney versus a statutory form. The common law is just a document that would be drafted from nothing. You could draft a power of attorney really, or an attorney can. versus a statutory form is a form that's been established. It's in statute. And the point of it is that that statute spells out exactly what the form does, who should accept it, what happens if they don't accept it, what kind of a liability the agent has if they do something wrong with your power of attorney. So it's very much the preferred document, that statutory form, because it's going to be widely accepted by banks and financial institutions, and it's going to give the principal, the person that's giving the power, lots of protections in terms of liability if something is done erroneously. The other thing that you might be referencing is the phrase durable power of attorney versus non-durable. What that is referencing is whether or not the power of attorney is effective when you're disabled. Now, most people, they're doing a power of attorney for that exact reason, for protection if you need someone to help you while you're disabled. So most of the time you want to do a durable power of attorney, so it's effective even when you're disabled. There'd be very finite reasons to do a non-durable power of attorney. That would be, let's say you have your house listed for sale, but at the same time you're going on this extravagant, once in a lifetime 2-month trip to Europe or something, and you want to give your trusted best friend here in the States your power of attorney for the limited purpose of selling your house. But you don't want them to sell it if they can't call you and walk through the deal because you're disabled. You've gotten in an accident in Europe. So you might make that a non-durable power of attorney, and you might also limit that power of attorney. So you might say it's only for this one transaction, and it's only for this amount of time, or give it an expiration. But most of the time when you're doing it for pure estate planning, you're going to do a statutory form, and it's going to be durable. Okay. Now, the piggyback to the power of attorney is the healthcare directive. So the healthcare directive is for your medical decisions. Many, many years ago, Minnesota used to do a living will, and you'd have a healthcare power of attorney and a living will. And now we've combined those into one document called a healthcare directive. It's a 2-part document. So you name your agents, and then you designate kind of instructions if you'd like on that healthcare directive. So the directive, unlike the statutory power of attorney, the healthcare directive is actually just a suggested form. So you'll see the healthcare directive in many different ways, in many different forms. A lot of medical institutions like to give them out to their patients or give you access to the forms. They're all valid as long as you fill them out, sign them. And then in that case, you need to have either 2 witnesses or a notary. A financial power of attorney is only a notary. It has to be notarized. But the healthcare directive can be witnessed with 2 witnesses. The caveat is that those 2 witnesses cannot be the people in your medical doctor's office, and they cannot be the agents on the directive, which is kind of interesting because there's absolutely no restrictions on who can witness a will, but there are restrictions on who can witness a healthcare directive. So your living will, if you have a living will, it's grandfathered in. But if you don't have either of these documents, you definitely should have a power of attorney and a healthcare directive. If you don't, that's kind of when we're back to that topic of guardianship and conservatorship. So if we don't have a healthcare directive, a guardian is the one who would make your medical decisions. They would have to be appointed by the probate court. And if you don't have a power of attorney, a conservator is making your financial decisions, and they are also appointed by the probate court. So kind of a long process of getting someone with authority. So I'm going to flip over to that slide here. I think we're to the end here. So some things to think about. If you were disabled, if you were disabled and unable to make financial decisions, would someone have the authority to make those decisions for you? That's, again, what we've been talking about. That's that financial power of attorney, really essential to get in place. If you were having a medical emergency, would your spouse or a loved one know your wishes? and even have the authority to designate those wishes. So again, that's the healthcare directive. So a couple other questions that come up sometimes are, can I use a trust to shelter and protect assets? That really depends on the trust itself. We talked a lot about kind of pure estate planning. So we're planning for your estate, we're planning for when you pass away, not necessarily planning for sheltering assets from the nursing home. I could talk to you for a whole hour about that topic, but that's something that does come up. But the main thing to point out is that there's no protection for revocable trusts. So those would be available for your long-term care. Do you know what would happen to your assets upon your death today? So if you have no will, where do they go? Or what does your will say? If you do have a will, have you read it recently? Do you know what your beneficiaries are? So those are kind of the big ones. Would your spouse or family need to open a probate? Depends on whether you have a probate asset or any probate assets. Do you understand the ramifications of designating beneficiaries on your account? I think if you didn't before today, you probably do now. Do you have long-term care insurance or sufficient assets to cover an extended stay in a nursing home? That's definitely something I would say talk to your financial advisor about. Are you comfortable with the estate planning you have in place today? So those are kind of some takeaways for everybody to kind of talk about. We're at the end of my slide here, so I will stop sharing my screen there. So
Yeah,
any other questions I can answer for anybody today?
Yeah, it looks like we're coming up on 3 o'clock, so we'll stick around for these last couple minutes if anyone has questions. Otherwise, thank you for joining us.
Well, thank you. Thank you for having me. I'm sorry I talked really fast, and I know we covered a lot in an hour.
Yes.
It's a lot to talk about, but I definitely am happy to answer any questions that anybody has. I know that's kind of the goal, is that you come with a question you want answered.
Mm-hmm.
And if you guys have a question after the seminar, and because you've forgotten or whatever, it pops up, or you wake up in the middle of the night and you're like, oh shoot, I should have asked that. I certainly am available. Erin, you have my email. That's an easy way to get me. I'm more than happy to answer just, basic questions about estate planning anytime.
Yes, yeah, I'll include some of your contact information too in the recap email. So if people want to reach out, they definitely can. We did have a question come in asking, how do you know if property is in a trust?
That's a great question. So certainly that can happen. Clients will set up a trust. They'll have this beautiful revocable living trust document, but there's nothing in it. And certainly that step 2 can be missed sometimes. We walk our clients through that. We want to make sure that they're doing that. We help them, we assist them. Now, let's say you're trying to review maybe your own plan or your parents' plan, and you're trying to figure out what is in the trust. You definitely want to go to the asset itself. So if it's, a piece of real estate, you're going to investigate whether there's a deed on record with the county. So it could be something that you call the county about. If it's an asset like a brokerage account, you're going to want to go to the account statement or the titling of the account, bank account, something like that. So you're going to go directly to that asset and not necessarily to the trust document itself.
All right, we had a question asking if you have clients in California.
So attorneys are licensed by state. I am not licensed in California. So if you're a California resident, you should definitely use a California licensed attorney. I'm licensed in Wisconsin, so I do work with clients who live in Wisconsin or have real estate in Wisconsin. But unfortunately, you can't necessarily represent attorney or clients in other states if you're not licensed there.
Mm-hmm. All right, next one, asking, can you distribute your assets when each person dies to bypass the 3 million limit total?
Can you distribute your assets? I'm not quite sure what that question is meaning. Can the married couple give their money at the first death to people, and then the other one give their 3 million at their death? Yes, you can do that. I mean, The estate exemption, the estate tax exemption is based on the person who dies. How much money are they giving when they die? So, and unfortunately, it doesn't matter how many people you give that to. So you can't, it's not 3 million per person. It's based on the total value in the estate. I hope that answers their question. If not, I hope they can or maybe clarify that.
Okay, we'll see. And then this one asks, is there a power of attorney that becomes effect only if you become incapacitated?
It's a great question. So this comes up quite a bit. So Minnesota's power of attorney, the statutory form that I'm talking about, is not what's called a springing power of attorney. It is effective as soon as it's signed, and sometimes that freaks people out. So they'll say, okay, I signed this power of attorney, I gave my son power of attorney, but I don't want him to use it if I'm not disabled. And unfortunately, there is not a statutory form. So we can't change the statutory form and call it a statutory form. So it would absolutely not be changeable in that way. You can do a power of attorney that only is effective upon disability. It's called a springing power of attorney. And what that power of attorney would say is that once my attorney, in fact, has proved my disability with XYZ, usually it's 2 doctor's letters saying I'm disabled, then they can act for me. The risk you take when you create that power of attorney, though, is that it's not going to be accepted because it's not the statutory form. So people aren't going to necessarily recognize it. So you really have to kind of weigh the risks and benefits. Usually once I talk to clients about, kind of that power of attorney situation, they can kind of overcome their fear. I always say to clients, if you're concerned about who you're naming, misusing your document, you're not naming the right person. Because if they're going to misuse it when you have capacity, who's to say they're going to use it correctly when you don't have capacity? So rethink about who you're going to name instead of worrying about whether the document gives them authority at the right time.
All right. Well, thank you so much, Amanda.
Well,
Hope everyone has a great rest of your day.
Yep. Thanks so much. Thanks for having me. Bye-bye.